Start, sir. We are live, sir.
Okay. Wait a minute. I'm tweeting and then I will give you the heads up. Wait.
So we are live.
Hello and welcome to Epicenter. No ambiguity, no noise. Let's come straight to the point. Epicenter is where we go straight to the issues that are often not discussed in legacy media. And if they are discussed, they are not given the importance or they are not dealt with the seriousness that they deserve. For years, Kashmir issue has been seen only through the prism of terrorism and national security. Given the magnitude of Islamist jihad that was launched against Indian state, this made ample sense. However, there is a tiny micro minority, aboriginals of Kashmir, Hindus of Kashmir, also known as Kashmiri Pandits, for whom this has continued to be an existential crisis, a continual genocide that continues to be denied. Whenever we talk about Hindus of Kashmir, we mostly talk about socio-political paradigm and we talk about their rehabilitation. The word justice has always eluded them. What does justice really mean? Justice, a powerful word, an emotion that all persecuted people pine for. What does justice really mean in the context of Kashmiri Pandits? I often say in my speeches and in my writing that in order to understand Jammu and Kashmir, you must first understand its geography, and then you must also be willing to go back in history. You must also get rid of convenient dates and go back all the way to 13th or 14th century. And you must look for the patterns which unmistakably are linked to the seventh Exodus and ethnic cleansing, both of which are part of continual genocide. Today, however, we are going to talk about justice. In a civilized and law abiding society, who does one expect justice from? The courts. Today, we'll talk about a timeline of what Kashmiri Pandits have gone through, their tryst with the legal system in the country in order to get justice. On September 2nd of 2022, this year, just a month ago, the Supreme Court bench refused to entertain a plea seeking directions to set up an SIT to identify the perpetrators who were involved in, aided, and abetted the alleged killing of Hindus and Sikhs in Jammu and Kashmir during the period of 1989 to 2003, and to prosecute them. The court then asked the petitioner, in this case was NGO We the Citizens, to approach the central government. They said it is purely in the domain of the executive. You approach the government, why should we interfere? At this point, the petitioner said they had not approached the government and they withdrew the petition. After this, a week after this, son of Pandit Tikalal Taplu, who was shot dead, one of the first Kashmiri Pandits who was shot dead by the jihadists, Ashutosh Taplu also approached the court, and he was also told his petition was also dismissed. He was also told that Supreme Court cannot interfere. In July 2017, a bench of then Chief Justice of India, J.S. Kehar, and Justice D.Y. Chandrachud dismissed a similar public interest petition filed by Roots in Kashmir, a body representing Kashmiri Pandits. The bench at that time said the instances referred to in the petition pertain to 1989-90 and they're more than 27 years later, 27 years later, the Supreme Court cannot intervene. It was at that time in 2017. 27 years had passed. Before that, a body of Kashmiri Pandits, Pan Kashmir movement, and All India Kashmiri Samaj had gone to National Human Rights Commission in early 1994. And in 1999, in its historic judgment, the commission headed by Justice Venkatacharya held the systematic and planned ethnic cleansing of Kashmir, and in his words, he called it akin to genocide. However, we saw no action after that. It is best to leave the affairs of the law and legalese to lawyers. So it's best for me to step out of it and invite, and it's my absolute pleasure and honor to welcome constitutional expert and a fine legal mind, Mr. Tito Ganju, to this episode of Epicenter. Tito Ganju, I can give a long introduction, but I will just keep it very short. He is known for his expertise in the field of law. Since 2002, he has been imparting the knowledge to law scholars. His subjects of expertise are jurisprudence, constitutional law, criminal law, international law, and genocide studies. He's the founder, owner, and publisher of Epilogue magazine and Epilogue News Network. He is also the founder of India's first genocide research institute called Jonaraja Institute for Genocide and Atrocities Studies, which will be officially launched in a few weeks. He is also the architect of Panun Kashmir's Genocide and Atrocities Prevention Bill 2020, which has been proposed and sent to GOI, Government of India, for its consideration and enactment. This is also the first and only proposed draft bill on genocide crimes in India. Mr. Ganju has been working tirelessly towards educating people about genocide and denial of genocide and its implications. And in the process, he has created a network of intellectuals and scholars who can talk about genocide. He has been leading campaigns to mobilize support for official recognition of Kashmiri Pandit genocide and enactment of the proposed genocide bill. Welcome to the show, Mr. Ganju.
Thank you so much, Sunanda.
Thank you. Um, Titoji, the problem for Kashmir is always where we begin. For the purpose of this conversation, I thought it might be best not to start from 1990, which is a convenient date and everybody knows that, but it is best to start from 1986, which, if you Google, was called Anantnag riots. But really, it was not riots because riots is when both sides clash. There weren't any two sides, as is the Kashmir story. There have never been any riots because both sides have never clashed. It has only been one side perpetrating crimes over the other. So in 1986, just to remind our audience, there was major anti-Kashmiri Pandit violence that happened in the district of Anantnag. In fact, it was best for me to recall or to read out a newspaper and a report from Times of India in 1986. And this will best encapsulate what happened there. And the news report and the little, what the reporter filed in Times of India in 1986, and I read it, quote, "The traumatic events of the past few days have left their mark on members of the minority community. They prefer to remain huddled up in their homes instead of venturing out. Their fears are not unfounded." This reporter, who was accompanied by a couple of Kashmiri Pandits and guides, witnessed at first hand the jeers and taunts directed at his companions while they were touring the rural areas of Anantnag, unquote. This is, I am reading directly a quote from a reporter who who reported from Anantnag in 1986. So my question to you really, Tituji, is that this was 4 years before we say that the entire machinery had collapsed, and in 1990 everything had gone. There was no state machinery. But 4 years before 1990, what happened after these riots? Did Kashmiri Pandits go to the courts? Did the state machinery help them? What did they do?
Well, as a matter of fact, we need to understand this entire, the saga under the ambit of genocide studies. We have to understand that whatever has happened in Kashmir right from 1947 onwards till date is actually part of the continual genocide which the community has been facing from last 700 years. When I talk about genocide, it's very important to understand that India is a signatory to Genocide Convention of United Nations. International Court of Justice has repeatedly stated that the convention actually embodies the principles that are part of general customary international law. And amongst those are the prohibition of genocide as well as the obligation to prevent and punish genocide. Now, when I'm talking about prevention and punishment of genocide, if you are talking, you started this from 1986. I will take you a bit, into 1961. 1961 was the year when census was carried out in state of Jammu and Kashmir. Because in 1951 it could not be conducted, so it was actually conducted in 1961. The total number of the population of Kashmiri Hindus was around 2,95,000. And then in 1981, the census number says that there were only 1,25,000 Hindus living in Kashmir at that particular time. In 2 decades, around 70% of the population diminished. And when between two successive censuses, if the population diminishes less than 10%, it's a matter of concern. Here we are talking about decline of population around about 70%. So, and nobody raised the question. And out of those 1,24,000, 25,000 were non-Kashmiri speaking people. And the responsibility of conducting an inquiry into this diminishing population was actually it was the responsibility of the state. And state has always has an important role to play because the convention also puts a lot of responsibility on the state. And then when we talk about 1986, it was rehearsal actually. It was the state if we see the processes or stages of genocide, it was eight stage when actually the people had started, the perpetrator had started planning of extermination, which happened then in 1990 or 1989. It started in 1989 and it was concluded in 1990. Thereafter, also, it has not stopped yet. If you go through the records, right from October 2021 to this day, 21 Hindus have been killed in Kashmir and they were all selective killings. So, genocide has not stopped in any case. Now, when we talk about the state, you know, based on experiences to date, there definitely is an increasing awareness that post conflict or genocide, these justice initiatives need to be very comprehensive, co- complementary as well, and in particularly they have to pay attention to the rights of victims. Though there is a emerging recognition that it is the responsibility of the state to provide justice for victims of genocide or of any armed conflict, and that sustainable justice requires three major components. One is the judicial accountability, truth, and reparation. But what we have been witness to is that there has been no response towards the reparation from the state of India. Now, when we talk about state of India, we need to understand one more thing. Most of the victims of these serious violations continue to suffer stigma. They continue to suffer with social exclusion and re-victimization as a consequence of lack of reparations and assistance in order to overcome the impact of genocide or armed conflict. And amongst these victims, most affected are women, children, and victims of torture or sexual violence. But whenever the genocide studies, the scholars or the field of genocide studies has always been marred by the, you know, they are actually attracted towards when something extraordinary, lure of extraordinary. We will never focus whenever even when you were talking about the petitions which were filed before the honorable courts, We are talking about the extermination, killings of people. Nobody can deny that they were brutal. They did not. The people who were killed did not deserve to get killed. Tragic. But nobody talks about the people who were left behind. They had to go through. The people who were killed passed away, but those who remained or who are living or who had to live, they have gone through this torture, this trauma. There won't be even a spur of moment in their lives when they could have ignored the trauma or and the trauma they actually endured during the time of genocide or thereafter. Nobody is actually talking about them. When we talk about, normally whenever we talk about the rape victims or rapes, and then like Girjatiku, it was horrible, it was brutal, but that doesn't make other rapes less serious,
Right.
or that doesn't make molestations which the females had to undergo, that doesn't make them less serious. They had to go through that trauma, and they are going through those traumas still today. So, first and foremost, we have to come out of this lure of extraordinary. You know, those people living in the camps in Jammu after this exodus, every day, every moment was the time of trauma. And I'm really sure most of them have not come out of it yet. So they are still living that trauma. And when in absence of reparations, it has actually impeded their ability to resume their lives and move beyond the trauma they have endured. They are not able to do so. So, when we talk about this, the reparation part of it, in 2005, United Nations adopted a resolution under the title of Basic Principles and Guidelines on the Right to Remedy and Reparation for Victims of Gross Violations of International Human Rights Law. They actually have put forth, four guiding principles for reparation. First is reparation, of course. Second is compensation. Third is rehabilitation, and fourth is satisfaction. When we say that we are caught up between genocide and denial of genocide, we know who the perpetrators of genocide are, who were the conspirators, where from it has originated. We know everything about it, and everybody else also knows about it. But who is denying the genocide? Denial can be done by the person or body or a unit or an entity which has the responsibility to recognize genocide. When we talk about recognition of genocide, admittedly state, whether through Home Secretary or a prosecutor in NIA courts in Delhi dealing with Yasin Malik case, they have admitted it that it was a genocide and Yasin Malik was involved in that genocide. But does that mean they have recognized it? If they would have recognized it, then the things would have been different, not like as they are today. The denial, right from the term used for us is migrants, to the people who are the employees, PM package employees who are actually protesting on the roads of Jammu. This is the process of denial. Process of denial includes the nomenclature, the term which is being used for us, migrants, and then there's an act which defines who a migrant is, just a sales act, section 2. And then when we talk about the elections, when we are asked to participate in elections, and in those constituencies which we belong to, you know electioneering is actually, if we vote for somebody, we want to ensure that our daily needs are taken care of. Now I am living in Jammu and I'm asked that I should shift my vote to Kashmir and vote from there. So government of India or state of India is actually trying to prove that the normalcy has actually, Kashmir has, we have been able to achieve normalcy in Kashmir. That's not true. So the denial includes this election also. Now, when we are talking about state, what is a state? It is very important to understand what a state actually is. State is defined in Article 12 of Constitution of India. And there are three organs of a state. One is the legislature, second is executive, and third is the judiciary.
Mm.
When we talk about legislature, we know the elected members of either house of parliament. They are the legislatures. Their responsibility is to enact legislation or enact laws. Second is the executive, which is the most powerful organ of the state. When we talk about executive, who are this? Who is this executive actually? Article 52 of the Constitution of India says there shall be a president of India. Article 53 says that the executive power of the union shall be vested in president and shall be exercised by him either directly or through officers subordinate to him in accordance with the constitution. But that means the executive, the real executive, according to Article 53, is the president. But Article 74, Clause 1 says that there shall be a council of ministers with the Prime Minister at the head to aid and advise the president, who shall, in exercise of his functions, act in accordance with such advice, making him a nominal head, and the real executive is the Council of Ministers and his Prime Minister and his Council of Ministers. So they are the real executive, and from there they delegate and sub-delegate powers to the administration, which in common parlance is termed as bureaucracy. This is the most powerful organ because they have the powers to adjudicate. They have the powers to legislate because rule making and ordinance are through them, and they have the inherent powers to execute the laws. So when we talk about the relationship between this real executive and the delegated, the bureaucracy, we have to understand that any officer who holds the post connected with defense or any civil post under the union holds office during the pleasure of the president. And every person who is a member of a civil state or of a state, he holds this post during the pleasure of the governor of the state. Now, we have understood that by Article 74, we are actually referring to Prime Minister and Council of Ministers or Chief Minister and his Council of Ministers. So the bureaucracy would always be subservient to this executive because they hold the post during the pleasure of the governor or during the pleasure of the president of India. Such is the relationship. Now, coming on to the third organ, which is the judiciary. Judiciary, though Article 12 does not, term them as state, but judiciary actually has two roles to play. One is the administrative role, and second is the administration of justice. The justice part is not a part of the state, but administrative part. While they perform the administrative actions, they are part of the state. And the interrelationship between these organs is very important to understand because we say that we have adopted the doctrine of separation of powers, but as a matter of principle, we have adopted separation of functions. So it's not like airtight cabins. They will not interfere in each other's actions, though they are meant to act as check and balances to each other. But as a matter of fact, there is an interrelationship between them because the appointment of judicial officers or to higher judiciary, state has a role to play in that. So they are interlinked, they are interrelated, and when we say that the state has denied this genocide, we are actually referring to all the organs of
Including judiciary.
yes, including judiciary,
Yeah.
including judiciary.
Yeah. Yeah, yeah, go ahead. Go ahead. Finish your point.
When we talk about that what has actually happened, we need to understand basic ideas or the basic sections of criminal procedure code which will make us understand this better way, in a better
Okay,
way.
so I will just stop you there for a minute, and I'm glad you gave us a sense of what the state is, because most people don't understand it, and you gave us a sense of that judiciary and executive. You said a very important thing, that there is separation of functions, but it's not, as we commonly understand. A layperson says that they don't go into each other's territory. What you are saying, that there may be separation of functions, but judiciary and executive, they sort of do work, they have to work each other. Otherwise, how will whatever judiciary says will be implemented? So my question to you is that when the Supreme Court on 22nd September, they for we the people, the organization, the NGO that had gone to them, they asked them a question, a counter question. Did you go to the executive? Did you go to the government? At which point, we the people, they said we didn't go to the government. So they said this is not our job. You need to go to the government. So my question, at which point it was withdrawn and they went to the question, which I'm not, that is what the NGO did. My question, and a lot of people here said that why would the Supreme Court say, why would they not take a stand on this? Why would they say go back to the executive?
Hmm.
That is the question.
You see, already Supreme Court, in a petition filed by RIK, Roots in Kashmir,
Hmm.
had given their observation
Hmm.
that 27 years now, they evidence will not be, they won't be able to come up with the evidence. So because of the time lapse,
Hmm.
so they rejected that plea. But for that, we need to understand these basic provisions of criminal procedure code.
Mhm.
You see, criminal procedure code can be divided into three parts with reference to the stage of proceedings it deals with. They are pre-trial stage, trial stage, and the post-trial stage. A fundamental portion of the criminal procedure code deals with the pre-trial stage, which may be referred to the investigation also. And what is investigation? Actually, investigation includes every documentation, search, collection of evidence, recording of statements, and recording of statements, including the victim statement, accused witnesses, alibis, and others also, and anything which is related to this. Whole part of this pre-trial procedure is stated in the Part 12 of Criminal Procedure Code from Section 154 to 176. They actually, these sections outline the basic procedure and actions to be taken by the investigative officers during the investigation. The pre-trial phase of criminal proceedings starts with the filing of the first information report
Hmm.
and ends with the filing of the charge sheet with the magistrate, right?
Hmm.
So when we are talking about that, why did it send back to the executive? Because the investigation was to be carried out by the executive.
Hmm.
It's not the responsibility of the judiciary, and least of all. And let us also try to understand this, that the petitions were filed under Article 32 of Constitution of India. They are all prerogative discretionary rates.
Hmm.
It's up to the judiciary whether they provide you with the remedy which you are asking for, or they can deny it also. But here in this case, they are not writs of right. They are writs, prerogative writs, and they are discretionary in nature. So when we are talking about this investigation part, it starts with whenever a police officer receives an information about any crime, he has to register it. Thereafter, they will go to the place of occurrence, and that technical term for that is Panchanama.
Right.
Thereafter, they start the FIR triggers the criminal procedure.
Hmm. Hmm.
In case of Kashmiri Hindus, we don't know actually. I'm honestly telling you, I have done a lot of work on it.
Hmm. Hmm.
I don't actually know the number of FIRs which have been filed.
Yeah.
The state is not clear also that what are the number of FIRs which were actually registered. Police in I think 2008 or 9 in an RTI response they said that 140 FIRs were registered.
Mm,
But then a figure came the 286.
mm,
Number of killings are known to none. How many have been killed in this time, time
mm,
frame? On the floor of house in on the its assembly, Umar Abdullah said 208.
mm,
There are records which mention 340.
mm.
And if you go through the appendices of District Sales Act, number of killings is 770.
Yeah.
State is not aware about the number of killings. And when we did some sort of research on this, there are more than 2,000 killings have happened between
Mm,
2,000 to 2,500. Exact number, no, nobody can actually you know
yeah.
come up with the exact numbers.
Mm,
The issue here is that they are expecting victims to pursue the cases of crime.
yeah.
While as if you go through any record, if you see the case diary of any case related to crime, it will always be state versus accused, whosoever it be.
Mm, mm,
For an unnatural death, registration of FIR is mandatory.
mm,
And why haven't they been registered? There's no response to that. Now, why haven't victims tried to proceed their cases or file the complaints or the cases in different courts? Understand the situation. After 1989, after particularly Exodus, nobody was sure about his future.
mm.
The present was much more horrible, and the thought of future was even horrifying.
Yeah.
It was responsibility of the state.
Mm,
Responsibility of the state was to conduct the investigation. They
mm,
did not.
mm,
Responsibility of the state was to register FIRs, which they failed in almost all the cases.
mm,
Even if they have registered these, let us assume that 200 or 140 FIRs have been registered.
mm.
Did they reach the charge sheet stage? No,
No.
they have not.
Yeah. So the question here is that in retrospect now, we don't know how many FIRs were launched. We know as a eyewitness, and you are also an eyewitness. We are both eyewitnesses of 1990. We know the situation. Saving their lives was when people are, it's very difficult in retrospect, and when you are not in the circumstances, it's very difficult for people to say that why didn't you pursue justice there, why didn't you go to the courts, why didn't you go to the police. They don't understand that when there is complete collapse of the system, when there was complete collapse of in J&K at that point, there was complete collapse of executive, judiciary, and legislation. I mean, there was nothing. No organ of the state was working. So, and for the longest time, no organ of the state was working. So there was really nowhere to go. Now, in retrospect, when we go back, the people are saying, the victims are saying, well, listen, we couldn't do it then, but that doesn't mean that we have given up hopes of justice. That doesn't mean that we're talking about rehabilitation, but we still desire justice. We still want justice because that is the only way known to a human mind where you can get closure to an extreme persecution. So you have to have a sense of closure. So my question to you is really, at this point in 2022, knowing that state can easily, I mean, the definition of state that you say, all three organs of the state can easily come and say that, listen, you did not do anything at that point. State had collapsed. Too bad. We have gone back from here. Now there is no way for us to go forward. So the best way for us is to forget about the justice part and move on to the rehabilitation part, which is what has been happening. That we need to forget about the justice part because there's really no way to get justice. Whereas victims are saying, yeah, we know the collaborators, we know who really inflicted on these crimes on us. They're still around. How can you say that there can be no justice? So we are caught in a log jam here because I think even I had written, and I have been continuously saying a position that I am now sort of trying to revise, that an SIT is needed. For years, all Kashmiri Pandits, including me, have been saying that we need a special investigation team. Please go and investigate. Please go and investigate. So, for what you've been telling me for last 30 minutes is that investigation is not even possible, because if investigation uh, is supposed to be the onus of the investigation is to be put on me as a victim, I cannot help the state. There is no way I'm going to get people who threaten me to run out of the house. So then, what remedy do I have? At this point, what remedy do I have? Because I don't have people, I cannot go back and find people who perpetrated this on me.
You see, there are two parts to your question. One is time, isn't
Yeah,
it? There's a statute of limitation. It's a law that sets the maximum amount of time that parties in a dispute have to initiate legal proceedings.
mm,
The length of time allowed under a statute of limitation varies depending upon the severity of the offense as well as the jurisdiction
correct.
it is being disputed. But cases involving severe crimes like murder typically have no maximum period.
Mm,
And under international law, crimes against humanity, war crimes, and genocide have no statute of limitation. So they cannot get away by saying that there's a time lapse.
mm,
Secondly, very importantly, CRPC, when we are talking about the procedure is there is an FIR, police is not acting upon it, and the SHO, local SHO is not acting upon it, then I have to present this, I have to inform the SSP of the area. If he doesn't do anything, then I have the liberty to go to the court under 156 and then file a complaint, and the court will initiate the inquiry. Right? Now, in our cases, neither the police nor SSP nor the court initiated this inquiry. So, what were the options left with us? NHRC was one of the options, which we did
mm,
in 94, 95. And after five, though the plea was rejected, but with an observation that it is ethnic cleansing akin to genocide.
mm.
So, now understand the phrase. I don't know what type of interpretation I have to use to understand this phrase. Ethnic cleansing akin to genocide. Either it is ethnic cleansing or it is a genocide. It can't be both.
And it came
Though,
from Justice Venkatachalaya, who was was a great luminary mind of India. It's not like it was an ordinary lay person who said this.
if you go through the entire, the observation, the order, which the order and the grounds of rejection, one of
Yeah,
the grounds is that Kashmiri Pandits are very resilient and very talented. They will go back to their, places, right? And then if they go back to then the substantial is not, it does not it does not fulfill the definition of genocide.
mm,
Instead of applying judicial mind, he actually applied a mind of some sadak chap astrologer who gave this prediction that Kashmiri Pandits are going back. It has been 22 years since then.
yeah,
We have not gone back, and there's no scope in near future as well.
yeah,
The manner in which selective killings are happening there. So there's, instead of applying the judicial mind, you are admitting that it is ethnic cleansing. Ethnic cleansing also is not a lesser crime, by the way.
yeah,
State has not investigated. No court has actually passed a stricture against the state, against the police authorities
yeah,
who were supposed to investigate these cases. How is it possible the cases which were handed over to CBI, it was Rubia Saeed kidnapping and Air Force cases, they are now in trial stage.
yeah,
Rest, no case has reached that stage. Not even a charge sheet has been filed.
yeah,
In his own admission, N.D. Vani, who was the judge of, who was chairing the proceedings of Beta Karate, Farooq Dar, he, in his order mentions
mm,
the prosecution is not interested in pursuing the case,
mm.
despite the cases having very serious nature. But the prosecution was not interested in
Okay.
actually. Forget about these. Now, let us say that after despite going to approaching NHRC, right from 1990 to 2021, Supreme Court has taken 46 suo motu cases in this time
Yeah.
period, right? And right from Yamuna, pollution in the Yamuna River to recently to the COVID cases, they have taken, and they have particularly taken certain cases which are referred under the particular incidents cases.
Yeah.
For example, the case that dealt with the fire that killed around 25 or 30 asylum inmates in Tamil Nadu. So the courts did not deem it, fit enough a case
Hmm.
where they could have taken so much cognizance as well. They
Yeah.
did. They have taken up cases on unclear media reports.
Yeah. But
They
in
have
this
taken.
case, when there was an NHRC, is NHRC thing which says akin to genocide, is this not binding on any organ of the state to follow up on this? Because I've always wondered, what does that statement that came 22 years ago, was any organ of the state bound by law to follow up on it?
Obviously, it's an observation.
And nobody followed up on it. Yeah,
No, nobody. That is why I'm telling you that there is an interrelationship between the organs of the state.
yeah, yeah,
They have to check and balance.
yeah, yeah.
But in this particular case, the state policy has been such to deny the genocide
Denial.
for whatever reasons.
Okay.
You see, judiciary has the powers to actually they can bring in international legal principles in national law.
Yeah, yeah, yeah. Quoting from that NHRC, I just want to quote here. It says, and I'm quoting, but against the stern definition of the Genocide Convention, the Commission is constrained to observe that while acts akin to genocide have occurred in respect of the Kashmiri Pandits, and that indeed in the minds and utterances of some of the militants, a genocide type design may exist. What does a genocide type design mean? Either genocide exists or
You
it
know,
doesn't exist.
Particularly there are processes to interpret law.
Yeah,
In cases of genocide or in grave cases of human right violations, you have to adopt strict interpretation rules,
yeah.
not liberal. Here, the honorable court, the honorable commission is confused.
Hmm.
They have understood by the pleadings. Probably they must have understood that it is a genocide,
Yeah.
but somehow state was not interested in
Interested.
declaring it as or
So,
recognizing it as a state, and I don't see any other reason.
from what I understand is that Kashmiri Pandit organizations went to NHRC, and this is what we got from NHRC, a muddled, what you call a sarak chhap kind of observations, which left us with nothing. Then we went to Supreme Court multiple times, and Supreme Court has been sending the ball to executive or has been dismissing for time lapse or something. It seems that no one seems to be applying any judicial mind to this issue. So, my question to you is 35 years later now, after abrogation of Article 370 and reorganization of the state, a new hope has emerged in Kashmiri Pandits where they feel that a judicial commission or an SIT, something similar to that, and this thing may be set up, and we have find all our hopes on an SIT or an judicial commission, thinking that they will be able to unearth all the atrocities that were committed to us. Why do you think, A, first, do you think this is the right approach to go now that we have come here and we've almost reached a sort of dead end? From here, do you think a judicial commission is the way to go forward, or an SIT is a way to go forward, or do you think there is an entirely new way that the state needs to look at?
You see, if we go through the history of commissions,
Mm-hmm.
what was the result of those commissions? Right from 1961, from Jabalpur Justice Shiv Dayal Srivastava Committee to recent, very recent Kishtwar Rights Commission, Gandhi Commission in J. We have to understand, a commission of inquiry can be appointed through the provisions or laid down in Commission of Inquiry Act 1952. Now, when we are talking about these commissions, we need to understand that the commission has the jurisdiction over that. There may be, they can be challenged at any given time. Though Commission of Inquiry has been given powers of a court for some purposes, but we have to understand that first and foremost, it does not decide anything conclusively, but merely gives its findings.
Mhm.
Second, there is no appeal against its findings. Third, it does not follow the adversary procedure, but is essentially inquisitorial in its approach. They can recommend. It's up to the government whether they accept it or not. That has been the fate of all the commissions, right from 1961 to Gujarat, or to Sikh rights in Delhi, or to Gujarat rights or Godra rights. There have been conflicting findings in Godra rights
Mm.
between Nanamati Commission and Mukherjee Commission.
Okay.
So, what are we going to get out of these things? These are just tactics. When matters go out of the hand and it has some political repercussions for for the party in power, they would appoint to avoid the noise which has been created. They to avoid those, they appoint these commissions, and it appears as if they are very serious to redress the issues, but
Mm.
fact of the matter is, till date, no commission has been able to deliver justice to India.
Okay.
Second, when we talk about the commission, one tribunal is important. We want a tribunal which is enabled by a law.
Mm.
And in this case, even if we say there are two, these SIT is something else, and commission is other thing. The commission of inquiry is something else. When we are talking about SIT, we know there is an order of the court, Supreme Court, in Roots in Kashmir versus Union of India. They have observed that because of the time lapse, we cannot find evidence. So they have already created a doubt.
Mm.
And if in such grave cases doubt is created, conviction is almost negligible.
Okay.
So now, even if today SIT is constituted,
Mm.
basic things have not basic preliminary investigation was has never happened.
Mm.
So we won't even be able to find out the original places of the occurrences. So what is the remedy left? And it is not because of us, by the way.
Yeah.
It is failure of the state, and they should take care of themselves.
Okay.
They cannot put onus on to us. For that, it is very important to actually enact a genocide law, and for that we have to understand that now the situation is such. After the this you know after the observation of the honorable Supreme Court, we have to reverse the onus of burden of proof. The
And on the state instead of the victim.
No, on the not on the state, but onus of proof has to be on the accused,
Accused. Hmm.
right? Because in the case, genocide is the rarest of rare cases, and
Right.
gravest of all, crime of crimes, right?
Yes.
Presumption of innocence is actually, it has that sort of constitutional guarantee, Article 21. We presume a person is innocent till proven guilty.
Mm.
But in the cases of genocide, it the onus has to be reversed, and there are precedents. The case by the title of P. N. Krishnalal versus Government of Kerala, where the court held that the presumption of innocence is not a constitutional guarantee and can be dispensed with by legislative imperatives and action. So, reverse onus clauses have been held constitutionally valid by the judiciary.
Yeah.
Recently, I think in 2021, a legislation was passed in UP for against this conversions. Section 12 of that is based on this reverse onus.
Okay.
So when we are talking about a commission, we should be asking that there should be a genocide law which will enable a commission which will actually, you know, lay down the formalities and the basic structure of the and the composition of the tribunal, which is enabled by law, which has the powers of that of a high court. They should actually go for this, and the Evidence Act has to be redefined, or we need, which
So,
has to be harmoniously constituted with the Evidence Act.
okay. So
But
what you are saying is just instituting an SIT in a hurry is putting cart before the horse. We're not going to get anything out of it. What we first need to do is enact a genocide law. Then under that, once a genocide law is enacted, under that, then we need to have a commission because they will be authorized then by the law to put the onus on of finding anything on the accused. Without the genocide law, and please correct me if you're saying this, you are saying without, and I want to clarify it for the sake of our audience, you are saying very clearly that there is no provision in IPC and CRPC at the moment that without genocide law, unless we do the genocide law, under the current laws, there is no law where we can put the onus on the accused. Is that what you're saying?
there are laws
Okay.
where this reverse onus is being actually implemented.
Mm,
But what I am suggesting is that the current, if we appoint a inquiry commission under Commissions Inquiry Act,
mm,
we will get no results. We have seen the results of other, right from 1961 to 2013, 2014 Kishtwar riots. Secondly, even if SIT is formulated or constituted to investigate into the cases,
mm,
what are we going to get out of that?
yeah.
In absence of a law, a genocide act,
Mm,
which will define, which will actually suggest a procedure how to go ahead with the investigation, how the evidence have to be taken or recorded. We need a comprehensive act.
yeah.
That is the only way that we will get justice. Otherwise, I'm sorry, I don't want to disappoint anybody. We will get nothing.
Okay. At this point, I just want to remind our viewers that if you have any questions, please send them to our Facebook link, to our YouTube link. We have a team that is working actively on it, and they'll be sending the questions to me. I have a few questions already. I'll be happy to ask your questions live to our guest. So if you have any questions, please send them to us, and this is the time we can get clarifications that we need because these are complex issues. And we often throw words like genocide and SIT and judicial commission. We just talk about them like a layperson. These are loaded terms, and therefore, before we use them in a conversation, we need to understand what they mean. And this is the time for you to understand. So, if you have any questions, feel free to send them. I'll be happy to take them. Tito, Minister of State for Home in February, while answering the question about India having genocide law, he said that Indian laws have provisions to take cognizance of crimes of the nature of genocide. He said Indian laws already have provisions to take cognizance of crime of the nature of genocide, like laws on culpable offenses. Therefore, I think what he meant was we don't need a genocide law because our laws already take care of those crimes. We have already established here that under current laws, it's very difficult to put the onus on accused. And right now, even now, after abrogation of Article 370, the lowest judiciary, the entire the um, population, this was also against a minority versus majority. The majority is still hostile, very hostile against minority. So I don't think there is any time any of them are actually going to even speak the truth before the commission, even though they are all party to it. I don't think they're going to speak the truth. And in absence of that, I don't expect any of them to be part of this, getting justice for us. in absence of any kind of cooperation from the majority community in Jammu and Kashmir, how can we say that the laws that we have are good enough to give justice or find the perpetrators or give some semblance of justice to Kashmiri Pandits? What is your opinion about this statement that Minister of State said?
Well, it's actually unfortunate. You see,
Yeah.
Indian Penal Code was enacted in 1861.
Hmm.
If it was potent enough to actually take care of grave offenses like genocide, what was the need of signing the convention? India was one of the proposers of the convention,
You're right.
and Indian Parliament ratified it in 1959. Right?
Right.
So there was no need of actually, such going for such a convention. Secondly, it's very important to understand that it's an obligation on all the states who have actually been the signatory to the convention, or who have, it does not matter whether they have ratified it or not. Customary international law puts this obligation, and it's binding on all states, whether or not they have ratified. They are under obligation to prohibit, to prevent, and punish the perpetrators of genocide.
Yeah.
And so, genocide is not simple homicide or
Right.
culpable homicide amounting to murder. It has other aspects also involved, right?
Right.
And when we talk about the genocide laws, all the countries which have enacted in their municipal laws this legislation, they have put the onus of proof on burden of proof on the accused, because the conditions of the genocide victims are such that, first and foremost, they are not in that state of mind. Secondly, the state is directly involved in the denial. Thirdly, the perpetrators, when we say that if you ignore or if you deny a genocide, it will replicate itself. It will replicate through two means, which we need to understand. It's not that the same perpetrator and the same victim. Victim has the ability to become a perpetrator as well.
Mm.
In our case, it's not possible because numbers are not in our favor. But the idea of punishment actually helps us in putting a deterrent.
Mm.
When a perpetrator understands that by my action, this will be the consequence. In most of the cases where severe punishments are awarded or given to the perpetrators, they have acted as
Deterrent.
as deterrents.
Yeah.
And when we talk of penology, there are theories of punishment. One is retributive, deterrent, reformative. When we talk of these cases of genocide, it has to be retributive. Under international law, there are only two concepts through which we can address these issues. One is retributive, and another is restorative. Restorative justice has been now the experts term it as part of denial of genocide. So the only thing left is retributive,
Literally.
and this retributive helps in actually acting as a deterrent to avoid such crimes in future.
Okay. So I have a.
So
Go ahead. Go
when
ahead. Finish your point.
when we're, when we're talking about the culpable homicide
Hmm.
amounting to murder, one thing is very important, that mens rea, the guilty mind, has to be established beyond doubt.
Hmm.
But in the cases of genocide, the motive of the perpetrator is different, right? In many cases, you will see that it is not, because of a guilty mind he is doing it.
Hmm.
He has an objective which he thinks is divine, and in our case, that is the case. He thinks is divine, and he uses everything which is sanctioned by the holy books. He executes them. He puts those actions in, whatever is written into action. So and these two things are entirely different: homicide and genocide. So when anybody, and particularly Ministry of Home, says that IPC Section 300 is capable enough to actually deliver justice or punish the perpetrators, which is obligation, binding on the state of India. Why haven't they been able to do it
Yeah.
right from 1989 to this date? They have not even reached the trial stage. Forget about conviction or
Okay.
punishment. Punishment is the last stage.
Yeah. So,
So,
your
India,
one takeaway from
India,
yeah, go ahead.
India, India needs a genocide,
Yeah.
but it is obligation, statutory obligation, contractual obligation, and obligation under international law.
Okay.
It is also the constitutional obligation.
Okay.
We have to foster respect for the, for the international conventions which we are signatory
Um, One takeaway from this conversation today has been that unless and until a genocide law is enacted, there can be no judicial commission or no SIT or no commission of inquiry that can reach to any logical conclusion that will be acceptable to everyone. Is what you are saying, that an SIT, an inquiry of commission will all, it will just be one more stage of denial of genocide instead of being, a part of confronting genocide. It will just be a denial of genocide because we're not going to get anywhere unless and until we enact genocide law. And you're saying India is bound to enact genocide law by being a signatory to the United Nations Convention.
and it has ratified also.
It
Though it
has,
doesn't need to be ratified because
so
the convention says so. ICG has many a times, say, in its observation, stated that it's not necessary to be ratifying it. Whether you have ratified or you have not ratified, you are bound to this.
yeah, okay.
And as a matter of fact, ICJ has granted extraterritorial authority
Yeah,
if a state is in a position to avoid or prevent genocide in its neighborhood, where he can use his influence, he can use any means
yeah,
to prevent that genocide.
okay.
And when we talk about Bangladesh or Pakistan, Hindus of Bangladesh, Sikhs of Bangladesh, or Pakistan or Afghanistan, India could have intervened if we had an enactment in place.
Okay. I'm getting a lot of questions actually. One question that has come from Krishnakant is, comparisons are often made between how Supreme Court handled 1984 Sikh riots and the exodus in Kashmir. In 1984, there were police complaints, witnesses alive, accused alive, etc. SIT looked at the past complaints, investigations, new charge sheets were filed, and a trial was held. For any relief for Kashmiri Pandits in Supreme Court, first of all, there needs to be an exercise to chronicle incidents, find any corresponding police complaint, analyze the investigation done or not, and then take them to Supreme Court and demand an SIT. Without any material, the exercise would be toothless. So I think he's trying to, without understanding the genocide law, he's pretty much saying what you are saying, that going to Supreme Court and asking for an SIT without having done this groundwork is pointless. What will Supreme Court do? Supreme Court is not an investigation agency in itself, so they're not going to be able to do anything. So unless we have this all this work done, and which can only be done under genocide law, can we then go to Supreme Court? Do you agree?
Once a tribunal is appointed,
Mm.
which is enabled by the law, genocide law, we don't need to go to Supreme Court.
Okay.
The current system forces us to go to Supreme Court.
Mm.
Supreme Court has not taken a suo motu action so far. Now, when we approach Supreme Court, and let me clarify one more thing, whether it was before the Honorable NHRC or Supreme Court, in any petition, we have not asked for reparation of genocide.
Mm.
We have been asking for investigations, we have been asking for rehabilitation, we have been asking for truth commissions.
Mm.
But that's not going to, help our cause. These toothless commissions won't help our cause.
Okay.
We will never get justice.
Right.
And it is the responsibility of the state, not of the victim,
Victor.
to chronicle the events.
Mm.
And when we say that we're victims of genocide and denial of genocide, as we already have discussed about it, that denial is from the state,
Hmm.
and state, all the organs of state have are responsible for denial of genocide.
Okay. Another question that is coming from Rajesh Handu. He says, hundreds dead, 5 lakh rendered homeless, not a single FIR or charge sheet. Is Supreme Court logic for not accepting Kashmiri Hindus' petition? That too, time has passed. Is it tenable? Sikh riots happened in 1984. That petition was accepted. What is judicial alternative if Supreme Court sticks to its position? I think we've already said, Tito has already said that we don't even need to go to the Supreme Court if we have the genocide law, and then under that, if we formulate these laws, we don't even need to go to the Supreme Court. I think we've already answered that question. There is one more question, fair and square. I don't know the name, but he says fair and square. We are
Mm.
pretty much fair and square here. So, right place, right platform for fair and square. He says, if our Supreme Court is refusing to hear these petitions, can they be moved to a civil court? Surely there must be some provision in our constitution to get these hearings.
So genocide is crime of crimes.
Right.
So that is exactly what my objection to judicial commission is. Also, one of the objections is a civil court,
Ah,
quasi judicial civil. It has the powers of that of a civil court. So
yeah.
we need a tribunal enabled by our legislation, which
Mhm.
has the powers are defined, the composition is defined, the jurisdiction is defined. So civil courts won't be of any help to us at
Okay.
this.
At this point.
It was never under the jurisdiction of civil courts.
Okay.
It's a criminal
So
court.
the question by Nikhil Talashi now. He says, in most petitions, the Supreme Court has dismissed the petitions. Is there a legal hurdle in that, or is there a bias? How should we look at such treatment of the country's highest court towards us? In fact, I had another similar question earlier, which said that are the justices of Supreme Court too woke to understand, or to the common terminology used as saying, are they too liberal or too woke to understand us? Is there a bias?
Well, I think I won't mince words in making the statement that yes, Supreme the courts are responsible for denial of our genocide.
So a bias is,
There's no doubt about it. I don't know whether it is bias or it is incomprehension.
yeah,
And fact of the matter is, even this, except for I don't know any other body except for Kashmir has
yeah,
been talking about genocide.
yeah.
No other organization has ever talked about genocide. So we didn't have the comprehension that what all we have gone through is a genocidal, act. So nobody approached it in it, approached this issue through the prism of genocide studies.
Yeah.
So blaming everything on Supreme Court or the state is not fair also, but it was their responsibility. Once NHRC made an observation, ethnic cleansing akin to genocide, the suo moto, if they could take suo moto cognizance of 46 cases, like, right from 1990 to current date,
Okay.
what stopped them? And secondly, one more thing which I wanted to add, when this citizens, we the citizens, approached the court on the asking of the court whether they have approached executive.
Hmm.
This organization, I think, were not aware of the fact that I can tell you with authority that thousands of representations have been made before the executive,
Hmm.
thousands resolutions, and through different organizations, but 90% of the content has been same.
Yeah.
So we have approached the executive as well.
Okay.
Our leaders have been part of the round table conferences with the state.
Hmm.
We have apprised them of the conditions there.
Mhm.
And you don't need to know rocket science to understand genocide. Whatever is happening in Kashmir, even today, how can you define it?
Yeah.
And when we talk about denials, and these three things are, you know, glaring examples of genocide, denial of genocide. Term migrant.
Hmm.
Number two, elections, wherein Kashmiri Hindus are asked to transfer their votes to Kashmir and vote from their original constituencies, which we have left 32 years back. and we don't know whether we're going back to that place or not. Thirdly, Prime Minister's employment package.
Mhm.
This- in case this matter is ever heard by a tribunal under a genocide act, I can assure you the, the complacency of the state is proven beyond reasonable doubt.
Okay. So, you are an architect of a genocide, Pan Kashmir genocide bill as well. Pan Kashmir's Genocide and Atrocities Prevention Bill 2020. I believe I have been told that it has been sent to Government of India for its consideration enactment. The bill is in public domain. I would request people who are listening to us to read the bill, to see what it says and try to understand it, and be aware of it. Do you see any hope for this bill to be picked up by the government in any in foreseeable future?
Very honestly, not very soon,
Hmm.
but definitely
Okay.
the state of India has no other choice but to. Important aspect which we are now focusing on is that majority of the people, even the victims, are not aware about what a genocide is.
Hmm.
So we need to impart training. We need to train them. We need to educate them. We need to make them aware about the nuances of genocide studies. What is a genocide? Everything cannot be termed as genocide.
Genocide.
See, I have seen filmmakers claiming that after producing a movie, the world has realized that Kashmiri Pandits have they have undergone a genocide, which is not true at all. The NHRC had in 1993 it was filed.
Yeah.
In its observation in 1990, it was not a particular filmmaker. He
Yeah.
even went ahead and said that the cases were reopened because of the movie.
Hmm.
For this Yasin Malik's or Farooq Dar's Beta Karatis. Fact of the matter is, Yasin Malik's case was opened in 2017 18,
Hmm.
and Farooq Dar's case was rejected by Supreme Court.
Hmm.
He was actually acquitted.
Yeah.
And now his brother has been contesting this case from last 30 years along with a friend of Satish Tikku. His name is Rakesh Undu. They are contesting from last 30 years. People have started, taking advantage of it.
Yeah.
People have that has to be stopped. Everything cannot be termed as genocide.
Yeah. Then
Cannot
because
term
if yeah, it's a legal term, and that's what I was saying. It needs to be
it.
used very, very carefully. You cannot just term everything as a genocide. It is like, I was speaking to a cardiologist yesterday, and I said I'm afraid to say that, if I say that my heart is fluttering, you might just take me into the hospital, because it is, in front of this thing. It's the same thing, that if I use the word genocide loosely, then it loses the impact of it, and it's the rarest of rare crime that has already been proven. Not every There can be gruesome crimes. There can be very, very painful crimes, and they happen all around us. We know that, but not each one of them is a genocide. And we have already gone. I mean, this is beyond the mandate of this show, and maybe we can do another show where we talk specifically about genocide. But even talking about, since Holocaust, since Raphael Lamkin coined the name, we're not even going to Jonah Raja, who actually is the father of genocide studies, which we'll do maybe in a show coming up later. But even if we look at just what the Western scholars have done, they have already defined genocide, and even by their definition, we can clearly come to the conclusion that Kashmiri Pandit situation is a genocide. I mean, it doesn't even need any further elaboration, and not everything else, not every gruesome crime is a genocide. Uh, there is a question by, and I'm almost reaching to the end of it. I've gone over time, but there are questions that are coming, and I really do want to answer this. Also, just a small bit, if people want to read the bill that Tito ji has been main pioneer, made an effort to write and put it out. It is on pkrehinge.com. Anybody who wants to go and read the bill, it's in public domain. It's for everyone to read. It affects everyone. It is not just about Kashmiri Pandits. It is truly about everyone who lives in India. Um, Ayush Tikku is asking a question. What should be the most accurate term used for Kashmiri Pandits, those who are victims, instead of migrants? Because migrants is we often keep, even in my writing, I've also always says that migrants refers to migratory birds. Migratory birds migrate at their own will. We did not migrate at our own will at all. So we should not be called migrants, but that word has stuck. And now, even though we call ourselves genocide victims, in official communication, we are still migrants. So, what is the best way to describe us if someone asks? I think it's a young student who is saying that what is the best, according to you, what is the best legal term that should define us?
For this young man, he is a genocide survivor, and people of my age, they are genocide victims.
Okay. So, genocide survivor and genocide victim. Those are the correct legal terms that we should use in this thing. I have almost reached the end of this show now, Tito. I have a question that I have really saying. Genocide is not, although ours is the only continual genocide in the world, there have been other genocides. And you are a genocide scholar. You have studied genocides across the world. I mean, that have been happening. In the end of this program, I just want you to give me a sense of how other societies and how other countries, quickly, if you can do that, have dealt with this. How have they efficiently dealt with this so that we can get some understanding, or we can, these can help us formulate our opinion as well. How have the other societies dealt with the justice part of genocide?
Well, actually, by bringing in laws.
Okay.
But if you tell me whether they have been successful in, giving justice to the victims, I don't think so. Reason being, it is a United Nations convention.
Mm.
Genocide is a United Nations convention, and it had to go through the General Assembly, and then it had to get, nod from affirmative vote from the members of the Security Council as well.
Mhm.
Three Security Council members were themselves involved in genocides. America, Britain, and France. They were all, colonial these countries,
Yes.
and since they were themselves involved in genocides of the Aboriginals, they did not allow cultural genocide to be part of the genocide, which actually is a part of genocide. And post, after the Jewish Holocaust, somehow the study has been dominated. Genocide studies has been dominated by Jews, and what they have done is something which rest of the world should learn. Memorialization is very important. For, you need to remember. You cannot forget what has happened.
Hmm.
Not It's not that it will give you some pleasure or sadistic pleasure. No, if you have to prevent a genocide, you have to remember, and
Hmm.
it is the foremost responsibility of victim to remember it, so that it is not repeated with anybody for that matter.
Yeah. So, Vishal Bhatt is asking a question that is there an implication of petitioners asking for justice without the context of genocide, which has been happening till now? Terms like targeted killings, ethnic cleansing, etc., are used. Does it deviate in, do people who petitioners who keep going to the courts, do they need to understand that this will actually deviate from the real cause of justice if they go to the court, if they ask for justice without the context of genocide. I guess we've been talking about that all through this show. You
my
can
my
answer the
pers-
next slides.
my personal opinion, and this is
Yeah,
my personal opinion.
yeah,
Yes, they are doing more damage than good,
okay,
because the petitions which are filed.
yeah,
I wanted to use a uh, not a very strong word, but they are flawed.
mm,
Primarily, they are flawed.
yeah.
And
So,
then you are not ask. What are you asking for? Somebody is asking for reinvestigation, which is or further investigation, which is prohibited by CRPC unless some
yeah,
new evidence has emerged. Somebody is asking for rehabilitation, and there are multiple prayers. So yes, they, and once the court has ordered the in particularly in RIK case, I personally believe, and the plea, the grounds which has been taken by Supreme Court are not fair,
mm,
because limitation statute or limitation period is actually for appeals and reviews and revisions,
mm,
not for asking for something, asking for a remedy, and then putting this time barrier.
yeah.
That was actually uncalled for, because there is no limitation period prescribed for a criminal act. Crime never dies.
Okay. So I'm going to end this now, but before that, I'm having my messages are
But
done.
just one moment. Just I wanted to add to this,
Yeah,
that
I
now
also have a last question. I also have, please ahead, and then I have one last question.
when Supreme Court says that it is not possible to gather evidence after 27 years, you have already created an alibi for the accused, if ever they are prosecuted.
Very important point. Very important point. The minute the Supreme Court said that the time has passed, you have already created an alibi for accused. And this is what our Honorable Supreme Court has already done in that petition of RIK when they said 27 years have passed. So, how can we go back to the Supreme Court without any genocide law and expect anything from them?
And
So,
for that matter, even from SIT.
even from SIT. When this has already been set up, that long time has been, this has already been, this is not a conversation that was held in anybody's living room. This is a Supreme Court order, and this is a Supreme Court pronouncement that time has passed. With such background, it would be foolish to go back to Supreme Court or to have a judicial commission and then expect any other different result. As they say, that if you keep doing the same things and hoping that there will be different results, you're going to be disappointed. So that no hills here. My messages are buzzing, Titoji, because we talked about the genocide bill. People want to know that quickly. If you could give us, and they are going to read the bill, which is in public domain, but they want to ask you, what are some of the salient features? If you can name top few salient features of the bill quickly, so that it will help them in understanding when they read the bill.
First and foremost, it has three. First chapter deals with genocide attempt and punishment.
Mhm.
Second chapter, part three, deals with cultural genocide, crime against cultural heritage and property.
Mm,
Then we have asked, in the bill has incorporated the methodology to conduct surveys of the properties and cultural heritages of Hindus of Kashmir.
mhm,
Then with it, we have also asked them to create how to constitute and constitution of a governing board for the shrines and places of worship in Kashmir, which belongs to Kashmiri Hindus. Prabandhak committees, which were the local bodies which used to manage the affairs of the temples before 1989-90. And then thereafter, we have also asked for creation of a genocide commission.
mm,
And we have laid down, we have suggested that in the draft it includes the composition, the authority, the powers of the commission.
okay.
And we have also given, I suggested them how the evidence would be laid, how evidence should be laid. So there's a chapter which is part sixth of the bill, which deals with rules of evidence. These rules are different from actual what are being the way the evidence are led. but are harmoniously construed with the Indian Evidence Act
Okay.
and with other international laws. These laws, this is the bill is actually the result of a comparative study. We have actually examined every other legislation which deals with the genocide, or which has been enacted by different countries, which has become part of their laws. We have done a comparative study of all the laws, and then we have come up with this. And it also deals with economic
Hmm.
genocide, because, as I said, in 2005, when this guidelines, basic guidelines to deal with the remedy of victims, right to remedy for victims of gross human rights violations was done, they lay down four principles. Uh, First was reparation based on refoulement, non-refoulement. Second was compensation. Third was rehabilitation, and fourth was satisfaction.
Yeah.
So it has to be based on these principles, because they are the guidelines which are already laid down by United Nations in its resolution of 2005. So these are broadly the salient features, if you see, of this draft bill.
Thank you so much. With that, I think we have covered a lot of ground today. We have talked about why going back to Supreme Court is probably not the best of things to do. We have talked about why judicial commission or any judicial inquiry or SIT, in absence of any genocide law, may not give us the results or will not be of any that would be acceptable to the victims of this genocide. So we have established that. This is a continuous conversation. This is not going to end here. I'm sure after you watch this and after you listen to the points that were made by T2G, you will have a lot more questions. We are happy to take more questions. There will be more episodes where we'll be talking about more such issues which normally don't get time in legacy media. Besides, they don't always have the experts to deal with it. So we are going to talk more about this, and we're going to pick up a lot more issues in the upcoming episode. Keep tuned to the social media handles of Epilogue and to Epicenter, and to their Facebook handle and YouTube. You'll get information about further episodes. At this point, I want to thank Mr. Tito Ganju for taking out time to be with us, to explain these things. Legalese is a very difficult thing. It is very difficult to sort of break down these issues to a layperson like me and to most other people who are not in the domain of law. So thank you so much. With that, we end this today. Thank you for being with us, and for more episodes, keep tuned in. Thank you, and keep watching Epicenter.
Thank you.